Okay, this is going to be jury selection, getting out of a jury, whatever I decide to call it, part 2. So, I should have made a note on where I was on that last one. I had to heat my coffee up. So, if you're on a jury and you're going to get up there, you're going to go through what's called a voir dire process where the attorneys get to ask you questions. First, you're going to fill out a questionnaire. On that questionnaire, they're going to ask information to kind of find out about you. Remember, they're looking for people, each lawyer, the defense who's representing the supposedly suspect, and the prosecution who's representing the state or the government. Now, you'll notice when they sit, the government gets to sit closer to the jury. And that's through psychological terms. Over time, they figured out that if the prosecution gets to sit next to the jury, we're closer in proximity, we can connect. People feel closer to somebody that's close to them versus the defense who is put on the other side farthest away from the jury. If it was fair, they would be facing or equal. But it's not fair. It's all for the government. The government is slowly increasing their chances and ability to win. So when you get on there, you're going to do a questionnaire, and they may ask your age, address. They're asking your age to see what kind of are. They know that older people, maybe for a trial, if it's a crime that's been around and that older people are more sympathetic to, they want older people. If they want the last, how many kids you got, that tells them if you're a parent or not. They may ask they'll ask a roundabout way whether you're married. I don't think they'll ask if you're married, but they'll ask a roundabout way. Again, lawyer tricks. What's the name of your spouse? How long have y'all been married? Things like that to figure out if you're married or not. Married people may be more sympathetic to crime. Married people may be more responsible. Married people may be living in a community. They're going to ask your address. Why do they want your address? So they can tell what neighborhood you live in. If you live in a neighborhood, you're desensitized to crime, they may not want you. But if you live in a really nice neighborhood, you don't have any idea about how bad the crime is in this other neighborhood, then they may not want you. So all these informations that you're asking on there is they're judging and evaluating, do I want this? And they've got a checklist, and they go through all this. When they go on jury selection, there's everybody's name. They've got people they want to kick off just from reading your answers here before they ever talk to you. But they're going to ask probably a question because you have to justify later. If somebody challenges, if you kick off a black person, and there's only one black person, and the defendant's black, they're going to say you kicked him off the color. So you're going to have to say why you kicked him off. So instead of just reading on here that this black person on jury has been arrested 6 times, has a criminal history, etc., so you know he's not going to be sympathetic to cops. You know he's got an aggression. The prosecution doesn't want him. You're going to want to challenge him. Challenge for cause. A preempt challenge is I don't have to give a reason. I get so many, like 3 each or something. A challenge for cause means something I found out tells me I don't want him. And then the judge gets to okay challenge for cause. The challenge for cause doesn't go against their preempts. So your preempt, I can go, I don't like you, you, and you. So I may ask you a couple questions to kind of confirm. So if somebody asks why I kicked you off, I can go back to my question. Well, when I asked them this question, I didn't like this answer. Okay, well that was good. As long as it wasn't for race or for religion or sexual gender or whatever. As long as it wasn't for that. Oh, no, you know you're going to get the truth when you ask an attorney. Oh, no, we would never do that. It was totally for this question. Okay, close. Remember, attorneys investigate attorneys. Great system we have here. Judges investigate judges. Attorney, yeah, okay. Remember, citizens are the lowlifes, and the only time that we get any respect is when you're on a juror. So they're going to read your questionnaire, they're going to figure out whether they don't want you or not, and then from there, when they sit you in there, they're going to be reading how you walked in, whether you were carrying a book on crooked prosecutions, whether you were carrying a book that says, I'm against the death penalty, or I think we should burn everybody for parking tickets. Whatever the book says when you walk in, they're going to be reading your book, they're going to notice you're writing a book, if you got headphones on, if you got sandals on, how you're dressed. Are you attentive? Are you like, wow, this is pretty interesting. I'm going to pay attention in the trial? Or am I like this? And they're like, dude, man, this guy don't want to be here. Remember, they're doing everything. Prosecution wants everything in his favor. So if he thinks for any way, shape, or form that you could be that one juror that says no, he's getting rid of you. Defense probably would keep, if you had him switch, if you made defense and prosecution agree to kick somebody off, man, then we wouldn't have very many people getting kicked off. Because the guys the prosecution want off and the guys the defense want off are usually opposite. So they would never agree on those. And that would probably make the system a little bit fairer and stop all this BS gamesmanship playing, kicking, choosing your specific jury just for your case. So then on the questionnaire, after the questionnaire is over, then they're going to talk to you. When they're talking to you, they're going to try to ask what investigations, and I guess attorneys call it too, open-ended questions. An open-ended question gets you to talk. A closed-ended question gets me to tell you something. So if I don't want you to talk and I know you're guilty and you're a suspect, I'm going to go, dude, you killed that person, didn't you? And they're going to go yes or no. That's a closed-ended question. I'm not soliciting information. I just want a quick, short answer. In voir dire, when they're asking you questions, they want open-ended. They want to hear you talk, because the more you talk, the more you may give up something that they don't want. Now they're going to say, we want you to give up bias. The reason why we're asking open-ended questions is because we want to identify your biases, and when we get you to talk, you may say that I know all lawyers are crooked and I don't trust prosecution, and then I can use that as a challenge for cause, and I don't have to use my preempt to get rid of you. Because I only have so many preempts, so I want to save those for my prejudices. I don't want to use them when I can kick you off because you open your mouth and give me another prejudice. So, when you're doing these cases, hopefully the person that I just did that to won't ask, well, sorry, Chuck. So anyway, if you're in up there, the reason why they say the only people on jury is too stupid to get off, if you're educated and you understand, you can get off jury easy. You either say something you know the prosecution doesn't want to hear, or you say something the defense doesn't want to hear, and they're going to kick you off. Okay? It's very easy to get off jury duty if you don't want to get off. Hell, probably watching this video, if the attorney watches it and you go, hey man, there's a guy, Rick, who used to be a cop more DA's office, he said I shouldn't trust the DA at all. That's probably enough to get you off. Because if they come back and look at this video, there was a blog in the jurisdiction I worked that was anti-DA. And that was one of their jury questions, is did you read or listen to this blog? Because if you did, prosecution was going to kick you. They didn't want nothing to do with you. Obviously, I got to button this down, sorry. So they're gonna get rid of you. So again, prosecution doesn't want people that don't trust them. Now to me, I don't give a crap whether you trust me or not. I'm going to do the right thing. I'm going to try and be as honest as I can, try to do the best job I can, and I don't really care. That's why when prosecutors used to come to me as a cop and try to go, well, could you leave this out? Or could you add this? Or no, I can't, because that didn't happen. Now, if I made a mistake and then put in there, oh yeah, that was in there, I'll add it, no problem. But when they ask you, and it happens all the time, they try to get you to make their case better. And the response at the DA's office, and places that have DA investigators, district attorney investigators, we tell a good investigator, we'll tell the prosecution, it is not my job to make your case better, it's my job to get to the truth. And a lot of times, prosecution don't want to get the truth. They got their case, they're ready, they're prepared, they know. If you find something that hurts their case, you'll be kicked from the case. They won't assign you. They'll remove some. They asked me one time to review for a use of force on these cops, and these people were going to sue the city. And the cops were dead stinking wrong. They didn't follow policy. They used too much force. They escalated the force higher, and I wrote it up just like that. You know what? It is what it is. The cops were wrong. Guess what? My report was never seen. The DA says, you know what? We decided to use someone else for the use of force expert. We're not going to use you. Thanks for playing. I was removed from that case, and they got one of their cronies who would go give the company line. The officers were doing their job, and under the circumstances, the use of force applied was appropriate for the situation. Yeah, whatever. Okay, now a jury may not, they'll never know about me. They never know that another expert. That's why a lot of times courts becomes a battle of experts. You have two experts saying two different things and it confuses the jury. Sometimes that's all it takes. And you know what? It should be. Because if the prosecution was being honest, they should be able to discount the other expert, and the defense will almost always try and discount the prosecution's expert. I mean, I've testified in a lot of cases as an expert. But you know what? The defense gets to ask me questions. I don't care. You can ask me. You can try to trip me up. You know what? The prosecutors be like, if they ask you questions, man, answer very short. Don't elaborate. Because if you elaborate, you may say something that he can go after. And that's called coaching a witness. Now, if the defense did that, the prosecution would be after them for witness tampering. But the prosecution does that to every cop and to every witness because they're the prosecution. They're the government. They can do that. Nobody's going to prosecute them. Who's going to prosecute them? DAs get limited immunity when they're doing their cases. Even if they violate the law, they can't be charged. That's why the system is skewed and it doesn't work, and I don't trust it. You shouldn't trust it. I don't think anybody ought to trust it. You need to question it, and you go into jury duty with a very skeptical, you know what, I'm watching the government. This is my one chance as a citizen to hold the government accountable. And you better have your ducks in line as a prosecution if I'm on your case. You know what? A good prosecutor with a good case would love to have me on the jury. Because if he did what he was supposed to, and he didn't hide, and he didn't try to manipulate, I'd vote guilty in a minute. But if most prosecutors don't want me on the jury. Why? Because most of them are manipulating and playing the system. As a juror, you should understand what kind of games are going on. When they call for a sidebar, most jurors are kind of like, what are they talking about? Maybe it's legal. You know what? If it was getting to the truth, why couldn't we all hear this? Why couldn't we trust the jury to be able to understand? Why? Because most attorneys think juries are stupid. They think everybody's stupid unless you're a lawyer, and they think other lawyers are stupid, so that don't matter anyway. But most juries are stupid, and the lawyers will say, shit, you know, I got this jury. Hell, the jury I got's the only ones that are too stupid to get out of jury duty. They don't care about... Now, when you come in the jury room, the attorneys will be standing, cross your hands, stand up straight, nod, look professional, all the big gamesmanship. When you walk in the room, all the attorneys stand up, they're playing you, trying to kiss you up as a jury. Remember, they always kiss you before they screw you. They're trying to kiss you up so you'll vote for them. So, I forgot to do my timer on here. Let me check the time on here. And then we'll go into some of the questions that they'll ask you. And I think you kind of get the point on how to get off. All right, I'm at 12 here. Let me turn down my timer. All right. At least I got a timer now so I can figure out what's going on. So what do you want to do if you're on a jury? What are you looking for to understand kind of what's happening? Sidebars. If you're having a lot of sidebars, things are being kept from you. You need to be skeptical. You should be able to read between the lines. When they're calling a sidebar on a certain topic, there's something more to that topic. Okay? You should be able to understand when there's an objection and they use terms like relevant, hearsay, but whatever the objection they use, the person objecting does not want you to hear something. As a critical ear and eye of a juror, you should be asking yourself, why can't I hear that? Why is he trying to prevent me to hear something? If the defense, prosecutors will tell other prosecutors when they're training them, you don't want to object too much because then the jury will start thinking you're trying to hide something. You are trying to hide something. If you didn't care and your case was good, man, say what you want. Ask your stupid questions. My case is strong enough to stand on its own. I don't need to object. But, you know, as a juror, you may not understand when they're objecting, which is why they don't want cops on juries, because we know, we've been, as a cops are told when they get on a stand, if they get to this topic and they ask this, don't answer, I'll object. We have pre-objections stated before we even get on the stand. You think the jury knows that? No. So the cop gets up there and he's all, well, I'm answering this question and blah, blah. And you answer this question and you see the cop glance over at the prosecution because he started doodling and forgot. And then there's a pause, so he looks up and he sees you staring at him. And I've done it before, to where a cop's like, dude, are you going to object or what? Because he's getting into things that I know have nothing to do with this, and he's just trying to, isn't it true this, and isn't it true, and he's trying to take me on a path. And, I mean, I don't really care when he asks me as long as he's not just playing a fishing game and it gets kind of old. Then the prosecution ought to, it's called protecting your witness. You don't want to let your witness get beat up. Cops are protected by the prosecution. And the prosecution wants to protect their cops. Why? because they want their cops to say what they want them to say so they can get a prosecution and they get a guilty verdict. They don't want to leave their cops out to hang. So many times after a case, cops will get in an attorney's desk and go, yo man, you need to stay awake. That defense attorney was going here, there, and there, and that's bullshit, and you should have objected. And you didn't because your ass was sleeping. So, well, you know, some attorneys be like, well, I didn't think it was, and you should be able to handle yourself on a stand. And that's true to a certain extent. I mean, I've been around long enough to where I can handle most of the games, but a younger cop who's inexperienced can get caught up and kind of just make himself look bad. Even though he didn't do anything wrong, so there's always this, again, it's never about the truth, about gamesmanship, playing games, confusing the jury, throwing up smoke, throwing everything on the wall, see what sticks. As a juror, your job is to sit back and go, why is he objecting to this? Every time this topic comes up, he objects. Every time they have a sidebar on this topic, every time this comes up, suddenly, Your Honor, can we have a recess and can we just excuse the jury for lunch? That's a way to get you out of there so they can go discuss what they need to discuss. Again, never about getting to the truth. It's always about hiding, manipulating, etc. Now, obviously, some of the suppressions that happen are supposed to be punitive to the prosecution. If cops go out there on the rogue and I start beating statements out of people and it goes to court and then that statement is suppressed, that's kind of like spanking the prosecution and the government saying you can't go beat people. So a suppression can be a good thing. However, the truth is the truth. So when the intent of suppression came out, it was to penalize and stop unethical, wrong behavior by the government, by the cops, by the people who had the power. If you do something wrong, we're not going to let you use it in court. That was the original intent. Well, now it's been morphed in over the years to where that ain't the intent anymore. The intent now is to confuse and hide and maybe get a mistrial. But remember, the attorneys sitting there are always getting paid. The jurors aren't getting paid. The judge is getting paid. The attorneys are getting paid. Maybe the jurors get lunch money for the day. But the only people there that aren't getting paid is the jurors. So when you sit up there and you watch these attorneys go on and on about BS, they're doing that sometimes as a feeler. They're doing that sometimes just to drag the case on. Because somebody that's getting paid, a private attorney, the longer the case, the more he gets paid, the more time he spends. Prosecution gets paid, doesn't matter how long the case. He goes back to the office and sits down, eats donuts, or he's in a courtroom, or he's at the gym. Doesn't matter. He's still getting paid. They're on salary, so it doesn't matter to them. But the jury, you want, when as a prosecution, your job should be able to get only information the jury needs to get the case, to get them to where you want them to go, which is guilty. And if you got a good case, you should be able to skip on it. If you're on a jury getting bored, and I've seen it, and I've done it as a cop sitting there, when you see a cop sitting next to the attorney, sometimes that's called the investigator of the case. They get to sit there so they can hear all the information. Well, there's a couple reasons for that. One is the cop sometimes has intricate knowledge of the case and little things that were done, and he can kind of help the attorney saying, hey, they just did this, but we did do this, but it wasn't in the report, blah, blah. So he can give kind of expert advice to the prosecution on this specific case because he worked it. He was the investigator assigned. Well, the flip side of that is, if I'm the investigator case, I get to hear everyone else's testimony, so I know who's going up, know who. So when I go talk to my cop buddies or I talk to someone else, now they know what everybody else says. Defense doesn't get that advantage. The defense witnesses are all kicked out. If you're a witness for the defense, you can't sit in a trial. You can't hear what other people are saying. They say, "Oh no, that's prejudicial. We don't want to mess up his testimony. We don't want to contaminate his memory. They got to kick you out." But again, as a cop, as a government agent working for the government, I get to sit in there and I get to hear everybody's. Okay? Now, when cops get off the stand, sometimes they're admonished, you're under oath, and you're not supposed to discuss case with anybody. Look, people, cops violate that shit all the time. When we get off the stand, we get out, we go to lunch, we're talking to the cops, we've been working this case, we're pissed off, we're going to talk about how the defense attorney did this, how the prosecution missed this, how I can't believe they didn't ask me this. Look, we can't control what we're asked. Sometimes we can elaborate and move on, but it's very difficult as a cop to get out the truth if we're not asked. Because the judge isn't going to allow it, the prosecution's not going to allow it. To me, it always bothered me, and I think I've said this in other videos, cops are not allowed to talk to the defense. Why? Because prosecutions don't want the defense knowing everything they know. Even though legally, they should know everything. It's called exculpatory evidence. You have to give everything you have to the defense. My whole case, I have to give to the defense so they know, so they can prepare their defense. When prosecutors hide something, that's considered illegal. They're hiding evidence. It's wrong. As a cop, I didn't want to be a part of it. I don't want to be a part of it. However, it's in that gray area to where the prosecution gets to decide what the defense gets and what they don't. It's up to the defense to find out that the prosecution hid it. Then the defense has to prove how that information would have done this. Then they got to prove that the prosecution intentionally withheld it. And I'm like, Jesus, all the burden is on the guy without the information. That's not fair. That's not getting to the truth. That's how we end up with guilty people in jail or innocent people in jail. I mean, our system is designed that 1,000 people go free rather than one innocent person goes to jail. That's the freedoms. Freedom isn't easy. It's expensive. It's hard. Sometimes it's bloody. But freedom is, it costs you. It costs lives. You know, for the military, we say freedom isn't free. We have to give up our families. We're in the military. We're overseas. We're fighting other countries. We're risking our lives. We're giving time away from our family. So freedom isn't free. But in the jury system, it's supposed to be fair, and it's supposed to be so innocent people can't accidentally get put in jail. We do not want our government being able to lock someone up unjustly without justification. Now, which is the same reason for a warrant. I talk about my search warrant case. In order to get a warrant, you need to be able to justify, convince a judge, have judicial review, have a third party review your case that's not involved and say, yes, I think you have probable cause. Well, now with all this freaking spying and listening to our phones and everything, there's no law. There's secret courts. There's courts that never get any type of approval. You can't challenge a warrant that's secret, that you never know, that's sealed and that you'll never know. That's called government power. That's called oppression, people. That's why the government, in my opinion, is on a quick path to fail. It's on a quick path to anarchy. People are about fed up with it. And either people are going to fold and turn into sheep, or they're going to fight back and say this ain't happening to our country, and they're going to stop the government. But one of the two things is going to happen, because we're on the path to just folding the government. And once the government gets our guns, we're gone for good, because then they're the only one with guns. But another topic. Okay, I'm anti-gun control. Most people know that. So as a juror, your job is to critically evaluate what's going on. What is the hidden meaning? What is it that you don't know? Now, the judge is going to tell you and the prosecution is going to tell you that don't worry about what you don't know. If you're sequestered, to me that's a big sign that your case is weak. If you got to lock the jury up so you don't want them reading any of the newspaper or anything slipping out, you got problems with your case. You know what? People are humans. Some people are going to be fooled by a media report. Some people are going to believe what they read. Whatever. If my case is good, I let it stand on the facts, and it is what it is. I mean, when I was younger, I'd get irritated when I lost a case, thinking that the jury was stupid or the prosecution was stupid or that dummy defense. Because you get interest. As I got older, I was like, I don't give a shit. You know what? I put together the best case. I know the guy's guilty. I've never put a guy in jail that I didn't know 100% that he was guilty. I just didn't arrest people for whims or maybes or ifs. They had to commit a crime. So I did the best job I could. If the jury lets them go, big deal. I don't care. Most attorneys don't think that way, especially prosecutors. It's all about my conviction rate. I don't want to go. I never want to get a not guilty. When I run for office later, I want to be able to say I had a 99% conviction rate. To me, that screams crookedness. When a guy's toting out, I'm saying, you're a crooked dude, man. You must have really bent some rules, hit some evidence, and did some crooked shit to get a 100% conviction rate or 99%. All right, well, I think I'm at 20, 25 minutes. I guess I'll do a 3 because there's a few things on the page If you're bored and you don't want to listen, that's okay. Just don't come back. I'm going to do a part 3 to this on the jury. I think if you're a juror, this is educational. If you're a cop and you haven't done a lot of jury jobs, it's also educational. We'll end that there.